Good afternoon. I'm Michael Eisenberg, and I'm your moderator for this afternoon's session of Law Track 14, about the 20th year that we have, from the ABA, have done a presentation entitled Hot Topics in Law. This is Hot Topics in Cyber Law for 2021. We have three distinguished ABA-based colleagues joining me this afternoon: Lucy Thompson, Steve Wu, and Catherine Barrett. All have been officers of the ABA section in Science and Technology, and all are expert in a variety of fields around cybersecurity law. Our agenda for this afternoon will begin with me giving some news headlines, things that have happened in the public space. Catherine Barrett is going to take over to present a discussion about new developments arising in the supply chain of ICT, information communications technology, and other sensitive infrastructures during the COVID period. Steve Wu is going to talk about the impact of some recent updates to the California data privacy law, as well as emerging issues in both data liability and AI. And Lucy Thompson is going to address some important implications of new cutting-edge legislation regarding IoT cybersecurity and regulations implementing that new legislation being developed by the National Institute of Standards and Technology. We have, as we do each year, some ambitious objectives for the session. We are always endeavoring to provide vocabulary and awareness of recent events and activities in the law of cybersecurity, and that's no different this year. We're going to try to bring to your attention the policy artifacts that we think bear remembering going forward, that are going to impact your practice, whether you are an attorney, a producer in the technology industry, or part of the consumer community. Catherine's objective is that we come away from today with an understanding of the transition in the concept of due diligence that's being visited on us by the COVID epidemic and the changes in transactional practice as a result of the important new due diligence elements and standards that are evolving. Steve is going to update us on some very important changes in policy coming out of state government from California, but having implications on a national and global level. And finally, Lucy, as I said, is going to be addressing new IoT legislation imposing cybersecurity requirements currently under development by NIST. We can go to the next slide, Steve. I'll start off with the headlines. These are things that we have selected because we feel they are pervasively important, or as the song goes, the stuff you gotta watch. Since January, there have been two critical new executive orders that have been part of a rash of rescissions of executive orders and policies that were put in place over the 4 years of the preceding administration that have important impact on cybersecurity and the cybersecurity infrastructure, and perhaps the broader critical infrastructure. The first artifact that I want to call out is Executive Order 14007 that was signed the end of January, entitled the President's Council of Advisors on Science and Technology. And it's important for a number of reasons. The important process issue that it addresses is the restoration of the President's Council on Advisors on Science and Technology, which had been abandoned by the previous administration and taken out of the arena of important advisory bodies that provide technical analysis for the White House staff. But importantly, included in that executive order are a number of important references to changes in science and technology advice that tee up a subsequent executive order from February 24th, EO 14017, on America's supply chain, which not only addresses the critical cyber infrastructure, but also critical goods, products, and services across the entire economy, and is leading to the legislative proposal currently under debate about our national infrastructure. But importantly, this executive order singles out and specifically identifies important technology artifacts, semiconductors, software, and other ICT, specialized batteries providing electric power to our information grid, and rare earth minerals, the core and sometimes hard to protect and hard to acquire substances like molybdenum, among others, that are in global commerce, but sometimes under the control of nation states that have adversarial interests to the US. Another important executive order is EO 14024 that was just signed in April, and it really addresses the solar winds hacks and the supply chain interdictions that have been attempted against the US, not only our national security and nuclear command and control network, but our election system and other critical infrastructures like the electric power grid. All of these changes in policy that have come from the new Biden White House have been backed up with, as I said, robust legislative agenda items, including the now pending critical infrastructure legislation that is wending its way through the Congress. Steve, if we could look forward. In order to shepherd these new policies, there have been a number of critical appointments on cybersecurity policy positions in the White House and in the agencies. The 5 people named on this slide represent a combined body of experience in excess of 100 years. Chris Inglis, who is taking over in the White House as the National Cyber Director in the Executive Office of the President, was former Deputy Director of NSA for cybersecurity. Ann Nuremberger, and he happens to be an attorney. Ann Nuremberger is also an attorney. She's the Deputy National Security Advisor for cybersecurity on the National Security Council staff. Others who are holding down important positions include Jen Easterly, who was a former NSA staffer along with Chris Inglis under Keith Alexander at NSA. She was also at the Obama White House. Rob Silvers is coming into the Department of Homeland Security as the Undersecretary for Strategy, Policy, and Plans. And Rob Joyce is coming back from a stint in the private sector to NSA as the Director for Cybersecurity. Each one of these individuals has a wealth of personal experience. Each one of them is very familiar to all of the others and represents a fabric of cybersecurity expertise across the senior leadership of the new administration that will importantly provide for a coherent program of policy that could only benefit those of us who are involved in cyber policy. If we could go to the final slide in this section. There are 2 artifacts that I want to call out to you. One is the Government Accountability Office's recent report released in March of this year as part of its high risk series that has elevated the concept of cybersecurity and its challenges to one of the 5 of the 15 high risk items facing the federal government. And it's important because it directs the federal government to engage in activities in 4 critical areas, addressing them as 4 critical challenges, including developing a cybersecurity strategy, securing federal systems and federal information and data sets, protecting the cyber critical infrastructure across both the commercial and civilian economies and the government, and protecting individual privacy and sensitive data, not only government classified data, but data that's sensitive to individuals. And finally, a companion document that might be viewed as something that rides well with the GAO report is the now year-old Cyber Solarium Commission report with its more than 200 recommendations. This bipartisan body spent more than 2 years gathering data about where do we need to go on cyber policy in this country. They released a report last year with the new administration and the new Congress. 6 pillars identified in that report are going to be anchors of the direction that those individuals I identified earlier are going to be pursuing in order to make sure that the US cybersecurity community and culture can benefit from legislative support, a useful working budget that funds the needed activities across both the government and the private sector and makes America more secure from a cyber perspective. And with that, now we're going to turn to the three presentations on hot topics in depth, following which there'll be some opportunity for us to discuss these issues amongst ourselves and to provide opportunities for questions from those of you in the audience. But we'll begin with Catherine Barrett and her discussion of the emergence of the new due diligence as an essential element of ICT policy, especially in the transactional space. Catherine?
Thanks, Michael. I appreciate it. So this pandemic has highlighted the growing concern organizations have about risks associated with their supply chain. Risks can arise from the lack of visibility organizations have into their information, communication, technology, supply chain. The lack of visibility organizations have into their supply chain is often because they don't identify and monitor how suppliers develop, integrate, and update ITC products and services. The risks can include, but are not limited to, the following, such as insertion of malicious code into the software, theft of intellectual property, insertion of counterfeits, and poor development and/or manufacturing practices. This presentation is going to focus on the need to conduct due diligence on suppliers prior to the acquisition of ICT goods and services. One cyber incident, the SolarWinds supply chain attack, focused attention on the need to identify, assess, and mitigate supply chain risks. The SolarWinds supply chain attack, as we know, and as the world learned, was disclosed in December of 2020. And while the investigation continues on how the hackers originally gained entry into the SolarWinds network, in April of this year, the US government officially named Russia as the nation state that carried out this attack. It's believed that Russia's Foreign Intelligence Service placed malware into the SolarWinds Orion software update, and that software update was subsequently distributed to more than 17,000 of their customers. Once inside SolarWinds networks, Russian hackers turned off security features such as logging tools and antivirus software to avoid detection and search for valuable information and data, read that data, and in some cases exfiltrated that data and information. So what was so unique about this attack? Three things. First, it was sophisticated. As Brad Smith, the CEO of Microsoft, indicated in his testimony before Congress in March of this year, unlike some attacks that take advantage of vulnerabilities in software, this attack was based on finding and stealing privileges and certificates and tokens that provide access to information in the network in the same way a trusted user would have access to it. Second, the scale. Microsoft estimates Russia used more than 1,000 engineers to execute the SolarWinds attack. And third, scope. The total impact is still unknown, but upwards of 17,000 SolarWinds users may have been impacted by this attack. So what to do? To reduce the risk of supply chain attacks, you need to incorporate due diligence into the acquisition process for all ICT suppliers of goods and services. This step will improve confidence and trust in your suppliers, improve visibility into one's supply chain, and reduce the risk of cyber-related incidents. Due diligence is not a one-and-done effort. Rather, it requires a sustained investment, a program within the organization to continually monitor for changes in the risk profile of your suppliers. A sample of major program elements might include, number one, supplier inventory and assessment. Create a geographic map of all your suppliers, including sub-tier suppliers of ICT products and services. Prioritize those ICT products and services. Which ones, for example, provide critical products and services to your organization? Identify substitute suppliers, if possible, for those critical elements. Manage a database of your suppliers and update it continuously as the risk profile changes of those suppliers. We often call this a preferred vendors list. And negotiate supplier contracts for ICT products and services where substitutes are not reasonable or possible. Another element of your program has to look at national security. For example, is there foreign control of or influence or influence over your supplier. Foreign ownership, personal and professional ties between the source and any foreign entity, legal regime of that foreign entity, where the resource is located or headquartered. Are there any suppliers listed on the Treasury's specially designated nationals block person list? So that might be something you need to know about. Legal, is the supplier located in the United States? If not, where's the primary or legal residence of that supplier? Does the supplier carry cyber insurance? If so, what's the extent of the policy? What's included and what's excluded from the policy? Has the supplier experienced any cyber incidents in the past 12 months? If so, what was the process the supplier used to respond to that incident? Were any fines levied? Any lawsuits filed as a consequence? Is the supplier willing to represent and warrant in writing that the supplier is in compliance with all applicable cybersecurity and data privacy laws in its own internal and external information systems and networks? Regarding incident response, are appropriate agreements in place with suppliers to ensure speed of communication, response, corrective action, and other related activities? Another essential element has to do with governance. Does the supplier have a supply chain risk management plan to manage their ICT suppliers? Does the supplier have a cybersecurity governance structure in place, including policies, procedures, standards, and controls to manage cyber-related supply chain risks? Do they have the proper roles and responsibilities defined in the organization, such as the role of the CIO, the role of the CISO, the role of the acquisition professional? Does the supplier have an incident response plan? There are several others we don't have time to get into right now, but asset management is another essential element. Does the supplier implement requirements to secure IT and manufacturing assets throughout the life cycle of the product or service being provided, such as identification and classification, media protection and disposal, records management? Does the supplier track and trace? Do they have a track and trace program to identify the origins of all parts, components, and systems? There's also another essential element is supplier operational awareness. Does the supplier devote talent, resources, and tools to track events from around the world in real time that could impact a supplier operations? For example, changes to a supplier's legal environment, such as laws that permit a supplier's government to compel a supplier to turn over data on customers, including potentially intellectual property and other sensitive information. Something like that should raise alarm. Does the supplier have an incident response plan, including roles and responsibilities of key leaders and staff? Does the supplier practice or conduct tabletop exercises of that plan periodically to ensure it is relevant and operational when an incident does occur? Asset management is another key element. Does the supplier design and implement processes and procedures to deny unauthorized access to facilities, equipment, and resources to protect personnel and property from damage? Does the organization impose tight controls on suppliers who have network access to their organization? And data protection, does the supplier have policies and procedures and tools in place to protect the data that it stores and collects and analyzes? Quality control is another essential element. Does the supplier meet relevant industry standards for cybersecurity practices and procedures? For example, do they rely upon NIST, ISO, other such industry standards? Does the supplier include security engineering and architecture best practices during the design and development, testing, and rollout of products and services? And testing is the last critical element I'm going to talk about, which is the testing. What is the testing process to identify potential vulnerabilities and defects? And does that process meet or exceed contractual requirements? Finally, there are several resources that I would point you to. We don't have time today to go over, but there are several resources that have a detailed checklist, if you will, of what ought to be thought of and included in a due diligence, from a due diligence perspective. One of the newest ones is from NIST, and it was just released in April of 2021. It's the Cyber Supply Chain Risk Management Practices for Systems and Organizations. They also have a great resource called The Best Practices in Cybersecurity Supply Chain Risk Management. It's a case study of how Cisco manages their supply chain risks from end to end. And finally, the Director of National Intelligence, the Office of Director of National Intelligence, put out in September of 2020 a short framework of how to assess and think about supply chain risks. Now I'd like to turn things over to Steve.
Thank you so much. Again, I'm Stephen Wu. I'm shareholder at Silicon Valley Law Group. It's a delight to to be with you today. And thank you so much, Michael, for your introduction. I have discussions here today to talk about updates to California privacy laws, digital liability, and artificial intelligence. But let's go back a second. Let's pull back and say what's going on here as a big picture. So we're coming out of COVID. We've had more mind share spent on data protection lately because people are working from home. So we're concerned more about that. And at the same time, artificial intelligence is marching onward. That technology is becoming the dominant technology of the 21st century. And with that, artificial intelligence comes a lot more intrusiveness into people's lives. So privacy is a bigger and bigger concern. We've had the General Data Protection Regulation from the European Union. We've had a long history of data breaches. And at the same time, people are starting to really get sick of all of these data breaches and dissatisfied with what's going on with the way that companies are protecting information. So that is motivating legislatures to take action. Democrats in Congress are focused on President Biden's COVID infrastructure plan, American Families Plan, the budget, and things like that. So there's a lot of things going on at the beginning of this administration. I'm not sure that we're going to have cybersecurity legislation anytime soon because of all those other legislative priorities. The Republicans have historically opposed any additional privacy regulations, taking the position that this might stifle innovation or put burdens on American business. So those are the kind of dynamics that are in the background. And as a result of that, state legislatures are beginning to fill the gaps. In California, where I'm located, the Silicon Valley Law Group is in San Jose, California. We've had a number of state laws coming to the fore because of these dissatisfactions and state legislatures seeing this opportunity to take on this problem. And in the absence of federal action, the state legislatures say, we're going to take action instead. So what do we have? We have the California Consumer Privacy Act, which is the nation's first cross-industry privacy law. It's not the first privacy law, but it's the first cross-industry privacy law, passed in 2018, effective January 1st, 2020, with some amendments in 2019. And I've given this talk before about what is CCPA, and there are many other programs in this institute about CCPA, so I won't repeat everything, but it's worth mentioning a few things. That there is a notification requirement for privacy policies for companies that are covered by the law. You have to tell people what you're going to collect personal information for. There's a right of access by individuals, California residents, to their information so that the company has to say, here's what we've got on you. And we also have this idea that you can take that information and then move it to somewhere else if you want to do that as a California resident. You have the right to ask the business to delete information, and you can opt out of sales of that information as California residents. There are some regulations with various notice and privacy policy requirements, service provider restriction, handling of access requests from individuals, identity verification to make sure that this person's really the person who's allowed to access that information about a particular individual, and rules against discrimination. That happened in the summer of 2020. But understand that CCPA only covers larger companies. And what I mean by that is $25 million of revenue or over, or 50,000 records of individuals, households, or devices, or data brokers, essentially companies that are making more than half of their revenue from selling data. And California consumers are the ones who are protected by this law. It's a California law. There's unlike some of the previous laws in California, there's a broad definition of personal information, which, I think in reality tracks the way the GDPR defines personal information. There is a data breach right of action, which is really interesting. So for a narrower set of ID theft potential information, there is a private right of action to allow individuals to sue businesses that lose control of their data. And there are statutory damages, meaning the plaintiff doesn't actually have to prove actual damages. between $100 and $750 per individual. So that's an important part of the law. Following on the California Consumer Privacy Act this year, in March, was the Virginia Consumer Data Protection Act, which similarly cross-cuts industries. That covers any company that has 100,000 consumers or data brokers with more than 50% of the revenues. So those are the thresholds for the applicability of the Virginia law. And like CCPA, there's a notice requirement. You have to tell individuals, if you're covered, what your privacy practices are and what you're collecting information for. There is this right of access, the right for an individual to have the business delete that information, the right to have access to that information for portability purposes, the right to opt out of processing information, and a non-discrimination like with the California law. It also adds, similar to GDPR, the right to correct information of record and the right against automated decision-making, so that can be opt-out. So what that means is like something like artificial intelligence. You might be able to opt out of that and have a human look at your the results of software processes and give a second judgment. The right of human intervention, the right of an explanation of what's going on. There's a data minimization requirement and security requirements now under the Virginia law. The companies have to have a data protection impact assessment, and if there are targeted ads or selling personal information, sensitive information, or high risk processing of information. But unlike the California law, there's only Attorney General enforcement. In November, we had the Attorney General, the California Privacy Rights Act, which is passed by ballot initiative in November. It adds to the CCPA, so it's not like taking over that in any way. It's not a substitute for it, but rather it overlays on top of that. It adds to the CCPA a new enforcement agency, regulator, the California Privacy Protection Agency. The threshold for applicability of CCPA/CPRA has changed so that you have to have 100,000 consumers or households or more to be triggered by this law. So they're really shooting for larger businesses here. But it may be for some businesses that are smaller, you might have that number of records too. It adds, like GDPR, this category of sensitive personal information that is entitled to more protection. And it adds this right of correcting information called rectification. You can restrict processing of sensitive personal information. It requires data minimization. Retention requirements have to be disclosed. And there will be regulations regarding automated decision-making that I mentioned in the Virginia law. Security requirements, risk assessments, and security auditing for high-risk processing. So we're now seeing the beginning of this trend, and we might see more state laws as time goes on. I'm also looking at a lot of data liability scenarios, I guess you could say. And data liability, I think, is going to become one of the bigger issues associated with our 21st century information technology environment. I was just reading today, we're recording this on May 7th. I was just reading today about how this company, Clearview Artificial Intelligence, is fighting for its life in court. Basically, what that company did was it scraped the entire internet for faces and put that into a database of faces for facial recognition purposes and artificial intelligence. And basically, there's a class action that is seeking a preliminary injunction that would have the effect, according to Clearview, would shut down the company. So where you get your data, how you collect it, and what you do with it are going to be key issues these days, especially with data being used to train artificial intelligence systems. So what can go wrong with this? Well, there are some scenarios that I would give you. One is the founders of OkCupid, the dating site, thought it'd been really cool to take the entire database of faces from OkCupid and give it over to this other company, Clarify, which then used those faces to train their facial recognition system. It almost sounds like there was a data breach going on, and certainly triggered a class action. It is true that there was a dismissal of the class action for jurisdictional reasons, but it's one of those things that, without asking anybody's permission, the company founders, maybe to even enrich themselves because they were also investors in Clarify, transferred the entire database of faces over to Clarify. So that's a cautionary tale. You need consent if you're going to do these kinds of things, and there has to be notice. And even that, you might trigger a class action because of the unfairness aspect of this activity. There was also a company called Flow Health, which was involved in menstrual and ovulation tracking. And this company apparently shared individual data with Facebook and Google regarding pregnancy cycles and fertility, contrary to what it promised in its privacy notice. These companies were using the data from Flow Health for advertising and product improvement. So what ended up happening was FTC came in and put down the hammer, basically, and now Flow Health is working under a 20-year consent decree that requires them to destroy the data they shouldn't have shared, provide notice to patients or individuals, users, and there's basically 20 years of oversight. I also want to mention there's a recent Federal Trade Commission blog post on April 19, 2021 about taking action against bias and the use of artificial intelligence. But for the final thing I'm going to turn to is the European Commission's proposed European Union Artificial Intelligence Act, which was announced on April 21st, 2021. It talks about promoting European Union artificial intelligence while protecting fundamental rights of EU citizens. If you think of it as what does this law really do? It combines privacy, security, product liability, anti-discrimination, national security, and youth protection all in one law. And it will, like GDPR, have extraterritorial effect. The companies that are covered, the US companies that are potentially covered, are ones that provide marketing or putting into service artificial intelligence systems in the European Union, regardless of the location of the company. It also covers users of artificial intelligence systems located in the EU, or providers and users of artificial intelligence systems outside the EU where the output produced by the system is used in the EU. And what does this law do? So American companies are potentially covered. What does this really do? Well, it prohibits certain AI practices like subliminal techniques, exploiting individuals based on age, physical, and mental disability, or applications likely to cause harm, social scoring systems, real-time biometric recognition systems like facial recognition. And at the same time, it regulates high-risk AI systems that cover health, safety, or fundamental rights, and unique risk management, pre-market testing, and conformity assessments, transparency, human oversight, accuracy, robustness, cybersecurity, and quality management. It also creates a European Artificial Intelligence Board, requires transparency, even for the low-risk applications, like you want the AI system to say, you're working with a robot here when I'm calling you up. And I think its impact will be very much like GDPR in its own area. I'll also mention that the American Bar Association Artificial Intelligence and Robotics National Institute will take place on October 12th and 13th. So watch out for that on the AmericanBar.org. There will be some announcements on that. And so what should you do, given everything that I've said? Well, you should know what kind of data you have, first of all, which is, what people have been talking about for years. But it's now really time to talk to your data protection team, start assessing your data risk. What data do you have? What are the risks? And then after that, understand your entire data lifecycle. Like, how are you really collecting this data? Where is it coming from? And where is it going? And then if you're finding out instances like OkCupid, like we don't know where this data is going, or it could be going to these other companies, you really need to stop and figure out what's going on within 3 months. And then within 6 months, you should have controls to ensure compliance for your personal data lifecycle and prepare for more artificial intelligence and legislation, because it is coming. So with that, I'm going to turn it over to Lucy Thompson.
Thanks, Steve and Michael and Catherine. IoT legislation is transforming the security landscape. The federal legislation that was passed this past December is called the IoT Cybersecurity Improvement Act. It's a bipartisan piece of legislation that was introduced by Senator Mark Warner and Senator Cory Gardner. And for the first time, it will be providing security standards for the weakest link in security, which is IoT. In addition, California, as Steve has said so well, is a leader in many of these areas with its legislation, has another statute that took effect in January of 2020, and Oregon also followed suit. Until now, IoT has been largely unregulated. Billions of consumer and industrial devices have been connected to the internet and to each other without any security or with little reasonable security. It's been a massive security problem. So looking to the future, it's predicted that 75 billion devices will be connected to the internet and each other. So it's time to take action. We'll start with the federal statute. The federal statute defines security standards and for IoT devices, and the hook that Congress used to pass this legislation is that the devices must be owned or operated by the federal government and connected to a federal information system. So where are the standards? They're not in the law. NIST is directed to draft the statutes and publish them, and on a 90-day time frame, so they should be published any day. What is NIST directed to do? They're focused on cybersecurity risk management, and specifically, Congress called out 4 areas that are of particular importance with respect to IoT devices. And this includes secure development, which addresses secure coding practices and supply chain risks. The next area is identity management, which has been the most problematic area for IoT devices, and that includes weak passwords, no passwords, default passwords encoded into IoT devices. So there'll be changes in that area. Also, patching. Most IoT devices are not capable of being patched, and configuration management, which is having the software configured properly. Most IoT devices do not support these functions. So there's 3 main things that will be going on that you should watch out for because it affects lawyers and their clients. After NIST publishes the standards and guidelines, for the implementation of the Act, OMB is directed to issue policies and procedures that federal agencies must follow. And the policies and procedures will be consistent with the NIST standards and guidelines. And their time frame is 180 days from when NIST publishes the standards. And then Congress has introduced a new initiative, which is guidelines for the disclosure of vulnerabilities that may be found on the devices. And they've actually specifically asked contractors and vendors to engage in a collaborative process where they'll issue coordinated vulnerability disclosure policies. So that should enable the manufacturers and the providers, as well as the government, to take action when vulnerabilities are identified to correct and remediate those. So turning now to California and Oregon, those 2 states took a totally different approach to IoT security. The most narrow of the 2 statutes is Oregon, which covers consumer devices. California statute is broader. It covers consumer devices and also may cover industrial and B2B devices. And the coverage comes from the definition of connected device. These statutes don't protect just personal data. They protect all data on the IoT devices. And they also cover the devices themselves. And any device that's connected to the internet as the statutes are defined. The enforcement mechanism is neither one of these statutes has a private right of action. So enforcement, as Steve mentioned, under the other California law, is done by the state AG or city and county attorneys general. No private right of action in Oregon. And the Oregon law is directed to manufacturers. So if a manufacturer violates the Oregon law, it's deemed an unfair and unfair trade practice. So enforcement will be done under the unfair trade practice regimen. These statutes actually try to define what is reasonable security, and that's a challenging issue. So I've included on this slide the 3 bullets that are what the states say reasonable security features should be. Appropriate to the nature and function of the device, this is the security. Appropriate to the information the device collects, contains, or transmits, and designed to protect the device and any information contained therein from unauthorized access, destruction, use, modification, or disclosure. So what does this mean in practice, you may ask? These laws are essentially very vague, and they do provide one clue about what is reasonable security by saying that a password, certain types of password management would be considered a reasonable security feature. So they give 2 examples. If a device contains a unique programmed password or the ability for a user to develop a unique password, then that's a reasonable security feature. But otherwise, these laws are quite vague, and as lawyers and security professionals, we're going to need to advise our clients as to what will needed to be done to these devices in order to comply with the laws. So there's a number of far-reaching implications that flow from this legislation. And the first one is an obvious question, which is, what is reasonable security? So we know under the federal law, the reasonable security will be what NIST says it is. And NIST has already published 4 documents that give us a deep dive into how they think IoT device security should be analyzed and managed. But what about California and Oregon? Since they don't provide guidance, will providers or manufacturers in those states be advised to follow the NIST standards? So the next question is, do these laws create a new standard of care? And you might say that that's very likely, because manufacturers and security vendors are going to need to have some guidance as to what they're supposed to be doing. And then here's a sort of a lawyer alert, which is there may be a single product with different versions for different types of IoT devices. So commentators have suggested that some manufacturers may create a, quote, government grade IoT device, which would be implemented on the government information systems. And then they may sell less robust, less costly devices for industrial or consumer use. So the question for all of us and our clients is this appropriate? Does it undermine the intent of these laws? And will companies that implement less secure devices be in jeopardy if a breach occurs? So that leads us to the liability risks, which Steve and Catherine have been talking about. Companies must determine what level of security they want to provide on the devices, and then what level of secure devices should be implemented in the information system. And there's a very interesting proposed IoT law in Virginia that's very instructive. The law hasn't been passed yet, but it has an interesting provision that I want to read to you because it's so interesting. That law says a provider of computing devices shall be liable for vulnerabilities that contribute to system breaches that compromise data when the provider fails to conform to the extent possible to industry standards for cybersecurity and resiliency. So the argument may be made just as what Virginia is considering enacting, which is if the manufacturers and the providers don't follow the NIST standards, they may be liable for a breach. So that leads us to a question of who would be liable for a breach. And we know there have been massive amounts of breaches. IoT devices have been used as proxies for many different kinds of criminal activity. There have been breaches of the data on the systems. So I threw out some ideas. These entities may be liable, and it could be the manufacturer, the seller, the provider, the tech integrator, or the data owner. And what about homeowners who use insecure IoT devices at home or in their workplaces? So there are a lot of potential entities that could be liable. And then in addition, who would be responsible for a breach? Because analysis of cybersecurity on IoT devices is a very complex analysis. And when you read the NIST documents, you'll see that there is a huge amount of analysis that NIST suggests be done. The breach could be a result of vulnerabilities on the IoT device itself, or on the network, which has to do with the interconnections between the devices, or in the IoT ecosystem. And NIST asked the question, are the devices utilized for the purposes for which they were designed? So there's questions about how the device is designed and then how it's implemented. One NIST document that you may want to take a look at is Special Publication 800-213, which is security guidance for the federal government, but it's also very thoughtful. And Section 3.1 has many different questions that data owners and manufacturers and providers of these devices need to answer. And NIST says that no one should underestimate the difficulty of creating a secure system in an IoT ecosystem. So what are the critical next steps? There's several ideas and suggestions for what should be done. The first is to understand the changing legal and security landscape, because this is a big deal and should be on everyone's radar. And so that's the first step. Read the NIST documents that have been published so far. There's a series of 4 of them called NIST Interagency Reports in the series 8259. So planning for publication of the NIST IoT standards and guidelines, you can look at these NISTers, as they're called. And another important thing is to inventory your IoT devices, and then think about the questions concerning standard of care and liability, and figure out what level of security is appropriate for your company or for your clients. And then implement controls that will be appropriate for the entire information system, including these more secure IoT devices. So now I'll turn it back to Michael.
Thanks, Lucy, and thanks to all 3 of you for very compelling presentations. It occurs to me in the more than dozen years that members of the ABA leadership have been doing Hot Topics, this is the first time I can remember seeing such a coherent thread run through all of the presentations of the hot topic issues. And I think we have a few minutes for discussion amongst ourselves. And I'd like to throw open the proposition that really comes to the forefront for me through work that I've been doing as the ABA's legal advisor to the Uniform Law Commission drafting committee on state level privacy legislation. And one of the things that has been really difficult in that exercise now in its third year is resolving issues around private rights of action and federal preemption. And it really begs the question of at what level can you write policy that's binding around issues, especially technology-driven issues that really confront the population of the entire planet. I recently participated in a webinar where that very question was posed. How can we reconcile a US privacy regime with GDPR in Europe? Does it make sense for a state like California, even though it's the sixth largest economy on the planet, to have its own privacy rules when that may be entirely antithetical to the rules adopted in a 600 million person country like Indonesia or 200 million Brazilians? Don't we need some fundamental ground rules that the entire planet agrees with, and efforts to harmonize legal policy in a way that makes the rules applicable to all of the citizens of the world joined together on the internet? I see that as a challenge, and I'd like to hear some conversation amongst the three of you about each of these areas of implementation of policy that really, while starting from a US focus, perhaps implicate a global demand pull for coherent policy.
Well, I have one question, which is, do you see this as something that might be the province of the United Nations Commission on International Trade Law to harmonize some of these laws?
Some international body certainly has to begin to address the fact that we are, whether we intend to or not, moving towards a balkanized system of policy that doesn't help resolve conflict when citizens from every country, from every jurisdiction within countries, are facing precisely the same challenges in terms of their inequitable posture vis-a-vis producers and other corporate players. How does an individual citizen get redress of grievances, whether it's a privacy breach or a liability consequence that's imposed on them because of poorly manufactured or poorly designed technology product? These are challenges not just for the citizens of San Jose, California, but for citizens of San Jose, Costa Rica, and other cities around the planet. And what are we going to do about it? So certainly the UN is a important candidate for taking responsibility for some sort of international harmonization.
Well, and it seems like the states are the place, the US states are the innovators, because we've mentioned California, Virginia, Oregon, and there's all of others that are really trying out different theories and approaches all over the country. And hopefully these best practices will come together in some coherent way.
Well, you know, I being outside of the Washington, D.C. area, I think I'm unique among all the panelists. And I would just ask the other panelists, what are you hearing about the prospects for federal data protection legislation these days? Or is it going to be backloaded behind all the things that Biden administration is taking off with to address the really key concerns of infrastructure and COVID and American families? Or what are you hearing about that in the Beltway?
I saw a panel of staffers who work on the privacy legislation, and then they said there's agreement on many issues, but private right of action is the sticking point. And so there's really just a few issues that they can't get bipartisan support. So there may not be anything passed this year.
Well, when our colleague Bob Gelman, who's been a privacy expert for decades, writes his periodic reviews, one of the things he likes to point out is that with more than 150 privacy statutes around the world, over 100 of them still rely on the FIPS, the 10 basic, or 8 or 9, depending on which version of the FIPS you like to point to. But the fact that nations around the planet, at least on privacy and data protection, tend to coalesce common views around some basic principles around the importance of notice and consent and right of redress. And it seems to me that wherever those new principles are adopted for a more pervasive global system, that they're likely to echo a common set of principles that are shared widely, and that set of principles may be the place to start, perhaps in that UN body that you mentioned, Steve.
Well, a controversial issue that I'm watching develop right now, I think we're all watching, is the vaccine passport issue. It directly impacts U.S. businesses and their ability to maybe reopen and bring folks back into the work environment. There's a lot of discussion about whether or not that can be forced. There's a lot of discussion about the Europeans. They're already rolling out, if they haven't already, they are rolling out vaccine passports to encourage, to protect public health, but also encourage opening up their economies back again. So one of the, as you were all discussing, the thing that keeps coming back is this controversy that's starting to brew at the state levels, but also internationally around what does a vaccine passport look like? Are Americans going to be comfortable downloading an app that's approved by an international standards body of data? What happens to that data? Which laws apply? What privacy rights do people have to that data? So I turn it over to my colleagues, but that's one of the issues that is very topical right now.
There's another item on the list, which is I was attending a meeting at the American Bar Association Cybersecurity Legal Task Force this morning, and there's discussion about an impending executive order from the Biden administration on cybersecurity. So Catherine and Michael, do you know anything about what that executive order is going to contain?
I know that one of my clients has seen the executive order already, but I'm not privy to what it contains.
Well,
The vaccine passports has really been a hot topic on the news, but it seems like it really, the issue is even broader, and actually HIPAA is going to need to be updated, and how healthcare information, particularly as it becomes more and more sensitive, is protected, is going to become an issue for the next few years.
I think we probably have a minute or two to take questions from attendees, and we should reserve that moment to do that. But I want to thank all three of you for the thoughtful presentations and the extensive preparation that I know it has taken to get this far. But let's hear from our attendees now and see what's on their minds. Again, thank you very much for being with us today.